You go to Google. You put it in Google. You press the, if it don't pop up, if it don't come up as a real case and all that, then you already know the paperwork is not valid. So I did this to that. The 38 Spesh paperwork is not fake. I repeat, the paperwork is not fake. If you copy the indictment number, go to Google, put it in there, hit the button, it's gonna pop up. Now what happens after that is a whole nother story.
Zip the
Alright,
legal
so as you
beagle.
can see, indictment number 07-172267-ROC-02 is associated with the criminal case against Justin Christopher Harrell in the state of New York. Case details: defendant Justin Christopher Harrell, jurisdiction New York State, typically associated with regional codes like ROC for Rochester/Monroe County or specific office or court administration prefixes. Format: the case prefixes 07 typically denotes the year of the initial arrest, booking, or underlying trafficking filing, while the specialized suffix formats points to specific state-level repository tracking. Because detailed criminal dockets and granular motion transcripts are rarely published in full on public search engines, you will need to utilize specialized legal databases to view the full indictment paperwork, specific charges, and ultimate disposition, how to access it. So you could do all of that all you want. You heard I'm not reading all of that. I asked, is this document associated with a real case and or is it real? It says yes. The document is associated with a real criminal case. The paperwork corresponds to an actual 2007 New York State criminal case involving a defendant named Justin Christopher Harrell, prosecuted by the Monroe County District Attorney's Office in Rochester, New York. Images of this specific document, primarily page 1, notice and disclosure paperwork, frequently circulate across hip-hop forums and social media platforms like Instagram due to its connection to the background or associates of the prominent Rochester-based underground rapper 38 Spesh.
Okay.
Authentic court details contained in the document. The jurisdiction is legitimate New York State CPL. Okay. The suffix, meaning the ROC, and the indictment index stands for Rochester. The contents: the specific page often seen online is a formal CPL 710.30 notice, which is a real procedural document used by New York State prosecutors to notify a defendant that they intend to use a statement made to law enforcement, in this specific case, a statement given to an officer, Brian Trumbley, at 185 Exchange Street, as evidence during the trial. I then asked, so did he make those statements? No. According to court procedure and the purpose of that document, the paperwork itself does not prove he made any confession or cooperated with the police. The document circulating online is standard New York CPL 710.30 notice. There's a common misconception on social media. Again, there is a common misconception on social media that receiving this notice means a defendant snitched or confessed, but legally, it means the exact opposite process is happening. It is a mandatory warning from the prosecutor. Under New York state law, if the police claim a defendant said anything at all during or after an arrest, even if it was just answering basic questions or saying, I don't know what you're talking about, the prosecution is legally required to give the defense written notice within 15 days of arraignment. If they fail to provide this notice, the state is completely banned from mentioning those alleged statements at trial. The defense routinely contests it. Just because an officer writes down that a defendant made a statement does not make it a proven fact. In criminal cases like this one, defense attorneys immediately file a standard motion to suppress. This forces a Huntley hearing, which a judge reviews whether statements was actually made, if it was fabricated by police, or if it was taken in violation of Miranda rights. The street context. The document is frequently weaponized on rap blogs and social media by rivals, such as in 38 Spesh's ongoing rap feud with figures like Jim Jones, to imply cooperation. However, in actual legal practices, A 710.30 motion is generated in almost every routine New York arrest where an officer claims a conversation took place, and it serves as a defense's tool to fight the prosecution's evidence, not proof of a confession. So, you wouldn't say he told according to this paper. No, you cannot say he told or cooperated based on this document. If a legal expert, defense attorney, or a judge looked at this exact paper, they would tell you it does not show cooperation. Labeling someone an informant or snitch based entirely on CPL 710.30 notice is a complete misunderstanding of New York criminal law. The paper confirms only the following legal facts. It is a document filled out entirely by the police and prosecution. The defendant did not sign this paper, write this paper, or agree to its contents. It is strictly a statement of intent from the district attorney's office. Statements do not mean cooperation. In a standard arrest, if a cop asks, "Is this your jacket?" and the defendant says, "No, it's not mine," or if they say, "I don't know what you're talking about," that is legally considered a statement. The prosecutor is legally forced to file this exact notice to bring up those brief words at trial. It is a tool used to fight the police. This paper is actually a trigger for the defense team. It gives the defense attorney the exact ammunition they need to file a motion to suppress, challenging the officer's integrity and try to get the case thrown out. In the legal system, a cooperation agreement or an official confession looks completely different, requires the defendant's signature, and involves explicit plea agreement. This specific document is just standard routine paperwork generated in thousands of ordinary New York criminal cases. If you want to understand what actual cooperation paperwork looks like or need help defiling other parts of a criminal court docket, let me know how you would like to proceed. And I just...
Yeah. Salute the drip.
I'm off.
Zip. Yeah.
Because I already knew that.
Yeah.
I looked at the paper and I'm saying, they saying that the nigga made a statement. The statement that they saying he made is not even saying that he saw somebody do it, that he know who did it. It was such a, it ain't even saying none of that. It's just saying he told the police, I don't know why they did this to my homie or whatever it say. You know what I'm saying? Yeah. But it's not really saying he told. It's saying that he made statements to the police. And but it's not saying what kind of statements he made to the police. Like, it's not saying he made incriminating statements to the police.
Yeah, you just said the statement.
Maybe y'all feel a different type of way, but to me.
Yeah.
But let Google tell it. That paper right there ain't saying he telling either.
It's not
so
valid.
Me and Google agree. Me and Google agree that 38 Spesh ain't do bad according to those papers that the people didn't put up.
Hey, yo. Shout to Zip with the drip for being literate enough to be able to break down everything that he was reading and actually make it make sense as far as, like, you know, pronouncing the words correctly and, like, flowing, like, you know, and reading like he's supposed to be reading, so we won't be all mumble jumbled based off of what it is that he read, man. It's definite. You could definitely comprehend what he read based off of, you know, the speculations about 38 Spesh. As you can see, man, the man is in the clear. He did not tell on nothing. It is what it is. They just gave, Zip just gave an example of giving a statement. Whether an officer asks you anything, is your coat red, blue, green, or whatever, and you give an answer, whatever answer you give is considered a statement. In 38 Spesh situation, he said, I don't know why they killed my mans. That was it. Not even like he don't know why someone would have killed his man. He don't know who killed his man, whatever the case may be. But it didn't go into no incriminating factors that social media is painting him out to be. So the boy's in the clear. He's not a rat. As we proceed, shout to Zip with the drip again, man. Y'all stay woke or wake up. I already know.